Hello Year 11s, welcome to this video on crime, the purposes of the criminal law and the types of crimes. There are three things that you need to do while you're watching this video. The first is to take the very best Cornell notes you can. The second is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you've missed out on any information or if you want to go back over any information. The third thing that you need to do is to have your vocabulary sheets open in front of you. This is important so that you can write into your vocabulary sheets the definitions of any key terms as well as the meanings of any words that you're unfamiliar with. When you've finished watching this video, please make sure that you read the textbook pages referred to on this slide. If you find any additional information from that reading that you think is useful, please supplement your Cornell notes with that information.
Here are your learning intentions for the first part of this video.
There are two learning intentions. You need to be able to define what a crime is and explain the purposes of criminal law. Make sure that you write each of these learning intentions down in your Cornell notes. This slide is by way of background. You need to be able to distinguish between a number of different aspects of the criminal justice process. The first aspect is how crimes are created. The answer is that crimes are created through statutes, that is, laws which are made by Parliament. As you'll see later on in this video, both the Commonwealth Parliament and the Victorian Parliament can make laws that create crimes. The Commonwealth Parliament makes laws about things that are crimes throughout Australia. The Victorian Parliament makes laws about things that are crimes in Victoria. The second aspect of the criminal justice process is how the criminal law is enforced. The police obviously have a major role in the enforcement of the criminal law. That is, they investigate crimes, arrest suspects, and charge those suspects. However, there are also other agencies that enforce the criminal law. For example, WorkSafe Victoria investigates and lays charges against employers who breach Victorian laws about occupational health and safety. The Victorian Environmental Protection Authority investigates and lays charges against people who breach Victorian laws that prohibit people from polluting the environment. The third aspect of the criminal justice process is how crimes are prosecuted. Generally speaking, it is the police who prosecute offenders for committing minor offences, also called summary offences. Summary offences are prosecuted in the magistrates' court. However, summary offences can also be prosecuted in the magistrates' court by other enforcement agencies, that is, enforcement agencies other than the police. These include WorkSafe Victoria and the Victorian Environmental Protection Authority. On the other hand, it is the Director of Public Prosecutions, together with the Director of Public Prosecutions staff of Crown prosecutors, who prosecute offenders for committing more serious offences called indictable offences. Indictable offences are prosecuted in the County Court or the Supreme Court. The fourth aspect of the criminal justice process is how an accused's guilt is determined. If the offence is a minor offence, that is a summary offence, then a magistrate decides whether the accused is guilty or not guilty. If the offence is a more serious offence, that is, an indictable offence, then a jury in the County Court or the Supreme Court will determine whether the accused is guilty or not guilty. The fifth and final aspect of the criminal justice process is the punishment of an offender. If the offender commits a minor offence, that is a summary offence, then a magistrate will determine the punishment for the offender. If the offender commits a more serious offence, that is an indictable offence, then a judge in the County Court or Supreme Court will determine the punishment for the offender. With that background, we can now turn to the first of our learning intentions. This learning intention requires you to be able to define what a crime is. I've set out the definition of a crime on this slide. Please look down the left-hand side of your vocabulary sheet, find the word crime, and write this definition in the box opposite that term. A crime is an act or omission that breaks an existing law, is harmful to an individual or society as a whole, and is punishable by law. Let's now break this definition down into its different parts. First, a crime involves either an act or an omission. Most crimes are acts. For example, in murder, one person does an act which kills another person. Perhaps they poison, strangle, or shoot that other person. Similarly, in the crime of theft, one person does an act which is the taking of that other person's property. However, some crimes may involve omissions, that is, a failure to do something. For instance, it is a crime not to report a stillbirth. A stillbirth occurs where a baby is born dead. Secondly, a crime is an act or omission that breaks an existing law. Generally speaking, it is a law made by Parliament, that is an act or legislation or a statute, that sets out what acts or omissions are crimes. For example, in Victoria, the Crimes Act 1958 defines a large number of crimes such as murder, rape, kidnapping, burglary, assault, theft, and so on. Third, the act or omission must be one that is harmful to an individual or society as a whole. In the case of an individual, a crime can cause that individual to suffer physical, financial, or psychological damage. For instance, where a person is assaulted, that person may suffer physical injury, such as broken bones, as well as psychological injury, such as a fear of going out because they are worried about being assaulted again. In the case of theft, the harm is financial because a person has been deprived of their property, for example, their money. However, crimes don't just affect individuals. They also affect society as a whole, and that is why, for a crime, the prosecution is undertaken by the state rather than by the victim. For instance, if there are a large number of assaults, then even members of the community who have not been assaulted might be afraid to leave their homes at night. That is an example of where a crime has an effect on society as a whole. And even where a crime does not directly have a victim, it may nevertheless have an adverse impact on society. For instance, being drunk in a public place may impose costs on society because that person might end up in hospital for treatment, or because that person may behave in a way that is dangerous to others. For instance, they might run across a busy road and endanger the safety of car drivers and other pedestrians. Finally, a crime is an act or omission that is punishable by law. For this purpose, a law, such as the Crimes Act, which creates a crime, will generally set out the maximum punishment that can be imposed for that crime. It is then for the courts to decide the punishment that should be imposed in a particular case. Typically, the maximum penalty is reserved for the worst examples of those kinds of crime. For instance, the maximum penalty for murder is life imprisonment, but the courts are able to sentence murderers to a lesser term of imprisonment, say 20 years, depending on the circumstances in which that particular murder was committed. You should all know that in Australia we have a national parliament, that is the Commonwealth Parliament, that makes laws for the whole of Australia, and that each state and territory has a parliament that makes laws for that particular state or territory. The Commonwealth Parliament has made a number of laws about crimes such as drug importation, terrorism, and the sexual abuse of children overseas by Australian residents. These are laws that apply throughout Australia, and so, for example, drug importation is a crime whether it is committed in Victoria or in Western Australia. However, most crimes that you'll be familiar with are contained in laws that are passed by the state and territory parliaments. These include murder, manslaughter, rape, kidnapping, burglary, and assault. These crimes can be different as between the different states and territories because each state and territory parliament is able to make its own laws about these kinds of crimes. As a result, there is not one single unified criminal justice system in Australia. Now we come to the second of our learning intentions, which requires you to be able to explain the purposes of criminal law. As you can see from this slide, there are three broad purposes of criminal law. The first purpose is to protect society. And criminal law does this by prohibiting behaviour that might damage the community, as is the case with drug trafficking, because that might encourage drug addiction, by prohibiting behaviour that harms individuals. A good example here is murder. That clearly harms the individual because someone ends up dead. And criminal law also prohibits behaviour that causes loss of or damage to property. We've looked at some examples of that being theft and vandalism. The second purpose of criminal law is to deter people from committing offences in the future. There are two kinds of deterrence. The first kind of deterrence is specific deterrence, which means that the purpose of the criminal law is to discourage the offender from committing future crimes. For example, if someone assaults another person and the person is put into jail, then the idea is that putting the person into jail will discourage them from committing assaults in the future because they won't want to end up in jail again. The other kind of deterrence is general deterrence. General deterrence means discouraging other members of the community from committing similar crimes. So if we use our example of assault again, the fact that a person has been sentenced to, say, 3 years imprisonment for assault means that that should discourage other members of the community from committing assaults because they know that if they commit an assault, they might end up in prison for 3 years. The final purpose of criminal law is to punish the offender. And this is very important because it satisfies the need for justice. It's important that the state punishes the offender and that people don't take the law into their own hands because otherwise we would have a breakdown in public order and safety. You can imagine that if a person assaulted one of your family members and the state didn't act to prosecute that person and to punish that person, then you might take the law into your own hands and gather a couple of your mates together and go along and assault the person who assaulted your relative. And then that person might gather their relatives together and their friends together and come along and assault you and your relatives. And clearly that's not a desirable situation because it means that individuals are taking the law into their own hands. So it is important that the criminal law does punish the offender so that people have their need for vengeance satisfied. Having listened to this video and taken notes, you should now be able to define what a crime is and explain the purposes of criminal law.
Here are your learning intentions for the second part of this video. There are two learning intentions.
The first learning intention is that you need to be able to define and distinguish between summary offences, indictable offences, and indictable offences heard and determined summarily. In addition, you need to be able to give examples of each of these different kinds of offences. The second learning intention is that you need to be able to define and distinguish between different types of crime which are classified by their nature. Again, in doing this, you need to be able to give examples of the different types of crimes. Make sure that you write each of these learning intentions down in your Cornell notes. One way in which we can classify crimes is by reference to their seriousness. Using this approach, there are three types of criminal offences. These are summary offences, indictable offences, and indictable offences heard and determined summarily. Summary offences are the least serious kinds of criminal offences. A summary offence is a minor criminal offence that is generally heard in the magistrate's court. Look down the left-hand side of your vocabulary sheets, find the term summary offence and write this definition in there. Once you've done that, highlight the words that are in bold purple type. Whenever you're required to define the term summary offence, try to remember to include the highlighted words in your definition. Now, because there's no jury in the magistrate's court, it is the role of the magistrate first to determine whether an accused is guilty or not guilty of the summary offence, and second to decide the punishment to impose on the accused where the magistrate finds them to be guilty of that summary offence. In contrast to summary offences, indictable offences are more serious kinds of criminal offences. An indictable offence is a serious criminal offence that is generally heard in the county court or Supreme Court before a judge and jury. Look down at the left-hand side of your vocabulary sheets, find the term indictable offence and write this definition in there. Once you've done that, highlight the words in bold purple type. Whenever you're required to define the term indictable offence, try to remember to include the highlighted words in your definition. Now, all criminal trials in the county court and the Supreme Court have a jury. It is the role of the jury to decide whether the accused is guilty or not guilty of an indictable offence. If the jury finds the accused to be guilty of an indictable offence, then it is the role of the judge to decide the punishment that is to be imposed on the accused for committing that indictable offence. Well, what then is the distinction between a summary offence and an indictable offence? There are two important distinctions here. The first is that a summary offence is a minor criminal offence, whereas an indictable offence is a serious criminal offence. The second important distinction is that a summary offence is generally heard in the magistrate's court, where there is no jury, whereas an indictable offence is generally tried in the county court or the Supreme Court, where there is a jury, as well as, of course, a judge. Now, in between summary offences and indictable offences, we have indictable offences that are heard and determined summarily. An indictable offence heard and determined summarily is an indictable, that is a serious, criminal offence that can be heard in the magistrate's court as if it was a summary offence. Look down the left-hand side of your vocabulary sheets, find the term indictable offence heard and determined summarily, and write this definition in there. Once you've done that, please highlight the words in bold purple type. And whenever you're required to define the term indictable offence heard and determined summarily, try to remember to include these highlighted words in your definition. Now, there are two conditions that must be satisfied for an indictable offence to be heard and determined summarily. That is, for the indictable offence to be heard and determined in the magistrate's court rather than in the county court or the Supreme Court. The first of these conditions is that the magistrate must be satisfied that it is appropriate to determine the case summarily. In determining this question, that is, in deciding whether it is appropriate to determine the case summarily, the magistrate must take into account both the seriousness of the offence and the adequacy of the sentences that the magistrate can impose. Here it's relevant to note that a magistrate can only impose a term of imprisonment of up to 2 years for one offence and of up to 5 years for multiple offences. So, for example, if the magistrate decides that, should the accused be found guilty of the offence, then an appropriate punishment would be imprisonment for a term of greater than 2 years, let's say 6 years, then the magistrate is likely to decide that it is not appropriate to determine the case summarily. Instead, it would be more appropriate for the case to be determined in the county court or the Supreme Court, where, if the accused is found to be guilty, then the judge can impose a term of imprisonment of 6 years. The second condition is that the accused must consent to the case being determined summarily. This is necessary because in having their case determined summarily, the accused is giving up their right to a trial by jury. That's because there's no jury in the magistrate's court. Having said this, an accused might be prepared to give up their right to a trial by jury if, for example, the case is one where the prosecution might be able to influence the emotions of the jury so that it's more likely that the jury would find the accused to be guilty. An example of such a case might be where the accused is charged with sexual offences against children. In such a case, the accused might feel that they have a better chance of being found not guilty where their trial is held before a magistrate rather than before a jury.
Now, it's also important to realise that not all indictable offences can be heard and determined summarily. Generally speaking, an indictable offence can only be heard and determined summarily if it is an offence that is punishable by a maximum of up to 10 years imprisonment or by a maximum fine of up to 1,200 penalty units. In Victoria, fines are calculated in penalty units, and 1,200 penalty units is about $200,000. So, for instance, murder, which is punishable by up to life imprisonment, and rape, which is punishable by up to 25 years imprisonment, can never be heard and determined summarily, because the maximum punishments for those crimes are greater than 10 years imprisonment.
This slide sets out the hierarchy of courts in Victoria and the types of criminal offences that they can deal with. As we've seen, the Magistrates' Court deals with summary offences, whereas the Supreme Court and the County Court deal with indictable offences. However, only the Supreme Court can deal with murder cases. In the Magistrates' Court, there is no jury, and it is for the magistrate to determine whether or not the accused is guilty of the summary offence. If the magistrate decides that the accused is guilty of the summary offence, then the magistrate must go on to decide what punishment to impose on the accused. In contrast, in the County Court or the Supreme Court, there is a jury, and it is the jury that is responsible for deciding whether or not the accused is guilty. If the jury decides that the accused is guilty of an indictable offence, then it is for the judge to decide the punishment to impose on that accused. In addition, indictable offences that are heard and determined summarily may also be dealt with by the Magistrates' Court. In such a case, the magistrate decides both the guilt of the accused and the punishment to be imposed on the accused if the magistrate decides that the accused is guilty of committing that offence. But remember, the accused does not have to consent to their indictable offence being heard and determined summarily in the Magistrates' Court. Instead, the accused can decide to have their trial in the County Court or the Supreme Court with a jury. This slide sets out examples of the three different kinds of criminal offences, that is, summary offences, indictable offences that can be heard and determined summarily, and indictable offences. I suggest that you pick two examples from each category of criminal offence and learn these. You can see that examples of summary offences include traffic offences such as speeding and being drunk in a public place. Examples of indictable offences include the very obvious serious crimes such as rape and murder, and examples of indictable offences heard and determined summarily include theft of under $100,000 and theft of a motor vehicle. This slide sets out examples of different kinds of crimes. For these purposes, the crimes have been categorised as offences against the person, offences against property, offences against morality, offences against the legal system, and offences against the state. I suggest that you learn one or two examples of each of these different kinds of criminal offences. Offences against the person are offences that involve conduct that results in some form of personal injury. Obvious examples are murder, manslaughter, assault, rape, and kidnapping. Offences against property are offences that involve conduct that results in damage to or loss of property. Again, some fairly obvious examples are theft, vandalism, and robbery. Most crimes are either offences against the person or offences against property. However, there are other types of crimes that we can also consider. Firstly, offences against morality are offences that are concerned with maintaining certain values in our society. So, for example, in Victoria, it is an offence to engage in incest, which is to have sexual relations between people who are closely related, or in street prostitution, which is where prostitutes solicit their clients off the street, as opposed to where clients visit a brothel to engage in prostitution. Now, these are offences against morality in the sense that they reflect certain values in our society. The view has been taken, in Victoria at least, that incest is detrimental to the proper functioning of a family unit, and therefore incest should be a crime. However, there are other countries where incest is not a crime. We also have offences against the legal system. These are offences that relate to our responsibility to participate as responsible citizens in the administration of justice. I've given you here a few examples of offences against the legal system. The first is perjury. Perjury is where a person comes to court as a witness and they swear that they will tell the truth. However, instead of telling the truth, they lie. That is, they lie under oath. That is called perjury, and it is an offence which is punishable by a fine or by a term of imprisonment. Another offence against the legal system is failure to appear for jury service. If you are 18 or over and are an Australian citizen, then you will appear on the Victorian electoral roll, and anyone who's on the Victorian electoral roll can be called up to serve in a jury. If you receive a notice to serve on a jury and you fail to attend and serve on that jury, then that is an offence. The final example I've given is the offence of contempt of court. Contempt of court occurs where a person refuses to obey a court order. And again, the punishment for that can be a fine or imprisonment. The final category of offences is offences against the state. These are offences that involve conduct that undermines the system of government. The most obvious example of an offence against the state is treason. Treason occurs where a person tries to overthrow the government by force, as opposed to vote against the government in a democratic election.
We've just looked at the 5 different types of crimes classified by their nature. That is, whether they are offences against the person, property, morality, the legal system, or the state. Include the definitions of each of these types of crimes that I've given you in your vocabulary sheets, along with 1 or 2 examples of each of these types of crimes.
Well, that brings us to the end of this video. Having listened to the second part of this video, you should now be able to do 2 things. The first thing is that you should be able to define and distinguish between summary offences, indictable offences, and indictable offences heard and determined summarily using examples. The second thing is that you should be able to define and distinguish between the different types of crimes classified by nature, again, using examples. Remember, you now need to read the pages from the textbook referred to on the first slide, and if you find any additional useful information from those readings, supplement your Cornell notes with that information. Thank you very much for your attention.